Good afternoon, everyone. The court calls Appeal 25-1575 Scott Trugstad et al. Versus City of Chicago. Mr. Lubin will begin with oral argument from you.
Thank you, Your Honors. May it please the court, counsel. Getting right to the heart of the matter, at least as it relates to the First Amendment claim, which was dismissed. There are two reasons that claim should not have been dismissed. We'll get later to whether the motion to reconsider should have been granted and for leave to amend. The underlying complaint that was dismissed was a good complaint. There wasn't any need to dismiss it. The first reason is that what Mr. Trugstad stated in his request for an accommodation was sufficiently religious. He stated he's a Christian and his religious beliefs prevent him from vaccinating, and he also said that he has a religious objection to the gene-altering nature of the mRNA vaccines. So and I know Passarella is a Title VII decision, it's not a First Amendment decision, but everyone seems to have analyzed, I did, my opponents did, the district court did, seem to have analyzed these claims under Passarella, which gives phenomenal guidance, in my opinion, really reestablished what the law always was in analyzing what constitutes a request for religious accommodation. And at least the context in Passarella was a request for an accommodation that was partially religious and partially secular. But what it said essentially is that it's not the role of the district court at that level, at the pleadings level, to determine whether something is sufficiently religious. That's potentially the role of discovery, but it's not the role of the district court at that level to determine that something is religious. If someone says that it's religious, then it effectively is religious. Now,
Mr.
obviously,
Lubin, most of the other opinions that state claims, or where we have found they state claims, have an extra step in there. You have two sentences, but you seem to be missing the identification of the religious belief in there. For example, most of the complaints that have passed 12b6 muster have an extra sentence about how that vaccine, under my religion, my body is my temple, and I won't put extra things in it. You don't have that in yours, so what should we make of that?
so he does allude to that in describing the fact that he objects to the mRNA vaccine, which is gene altering. He doesn't say it. That's true. I've seen a lot where it's my body is my temple, and therefore I don't want to alter my genes. So he doesn't say that, but I think one can infer when he says that as a result of the mRNA gene altering nature of the vaccine, he has a religious objection to it. That's clearly the inference, and he goes further in his discussion with the city, but at least on the pleading that was struck, this is what was before the court. I wish he had said more. Obviously, he wrote it before I was involved in his life, but what he said was sufficient. And one of the reasons it's sufficient is because it really is the role of the deliberative process to then get into that step that Your Honor points out. Okay, fine. Explain to me how X connects to Y. And the city didn't do that, and that leads to the second reason that it was error to dismiss the complaint at that point, which is in general, and once again, here the procedure is outlined under Title VII, not the First Amendment, but the analysis is pretty similar. It was up to the city at that point to say, get me from point A to point B. Instead, what they said was, and they acknowledged, by the way, in their response, that it was a religious belief by saying, how long have you had this religious belief? In other words, what they were jumping to is the question of sincerity. Really, are you sincere in your religious belief that you claim to have, or did you just make this up in order to get out of the COVID-19 vaccination requirement?
So your point with that, Mr. Lubin, has to be that the city had to have read his request as religious, because otherwise their response makes no sense.
Correct. Yes, I think the city read it as a request for an accommodation under religion, and they followed up with
a question about religion.
A question about the religion, right? How sincere are you in this religion? And once again, that's a question for discovery. That really isn't a question for pleading, so that's not why the district court denied it anyway.
Can I ask you a question about we're not talking about the Fourth Amended complaint. I suspect you will here in a minute, but we're on the Third Amended complaint, correct?
We are.
Okay. And the Third Amended complaint, by its terms at the very end, asks for damages. But I think the Fourth Amended complaint, and maybe the second, also had a request for injunctive relief. So my question is this: to your knowledge, as you stand here today, does the city of Chicago have in place a vaccine mandate?
I have no idea. What I know is that most of the people who requested an accommodation were given an accommodation. So whether they have a mandate or not may or may not be material. There was a small handful that were denied. Mr. Trugstad was one of them.
So Mr. Trugstad's complaint, by its terms, or at least the one we're talking about right now, is simply for compensatory damages.
At this point, yes.
Okay.
Not reinstatement? I believe at the end of the third amendment complaint, it talks about damages and reinstatement.
I mean, if we want to, I'm sure he'd take it. I have no idea. But really what we're looking for, yes, is compensatory damages, yes. As applied challenge, seeking compensatory damages.
Okay.
And I think we're entitled to reinstatement as well, but I don't think that's,
Well, okay, but
what
hold
we're
on.
talking about
Don't get going too fast here. I mean, Judge Brennan's question is a serious one. I mean, there is a request for reinstatement. Is that on the table, or are you waiving it?
I'm not waiving it. I just wasn't prepared to answer the question. So I'm standing on one
Well,
foot.
I mean, in somewhat, I mean, it's not a great question for you. The folks at the other table will know the answer to that, and we'll ask them that question in a few minutes here.
Okay, that's fine. I mean, it's what's sought in the complaint, but obviously the bulk of it is the compensatory damages.
Okay, but there's nothing being waived.
No,
Okay, I got it.
not willfully as I stand here. Maybe I'll realize later I should have. But no, not as I stand here now.
Oh, we're not trying to trap you with the question. We're just trying to figure out the scope of what's in front of us.
No, I understand. I wasn't making light. I'm just saying that I don't know the answer as I stand.
All right.
And
Is
I'm standing
Mr.
with the complaint
Trugstad
says.
working
Yes.
somewhere?
Yes.
So he's working somewhere else?
Yes. Yeah. As I understand it, he's happy where he is. Going to, well, I don't have a ton of time. In terms of the leave to amend, the court found with respect to Title VII that the amended complaint was sufficient, and then said it's too little, too late in terms of this complaint. And it was the third amended complaint that was the first one in which the court said, "Tell me what the specifics were of this request," and it was also the first one in which Trugstad was the only plaintiff. Up until that point, the complaint really was as to all the people that were listed, and including similarly situated individuals. The court essentially said, no, this is going to be only an as-applied complaint, only people that were denied their accommodation, which is certainly fair. So the third amended complaint was the first time that was addressed in writing, and so to say too little, too late is in my opinion incorrect. And certainly since the court found that the fourth amended complaint, or almost something that was almost virtually identical to it, did state a claim, it was error to deny request for leave to amend. I forget whether I asked for 3 or 2 minutes, but I guess I'll take 2 minutes and I'll speak for 30 more seconds and then hand over the floor. In terms of the substantive due process claim, look, obviously in order to grant the relief I'm looking for as it relates to substantive due process, I don't see how you could do it while still upholding Klassen. But for the reasons that I laid out here, I think the court should consider rethinking Klassen. And thank you very much for
Mr.
your
Lubin,
time.
before you go, the district court did not consolidate the cases, did it? I know discovery was consolidated and the court addressed the motion
Correct.
to dismiss, but I want to make sure this is right for appeal. So
Yes.
did it?
The cases, I'm sorry.
Did it consolidate the cases? It didn't seem like that looking at the docket, but there was a little bit of confusing language in the order.
They were separate dockets. They remain separate dockets.
Okay.
What the court did was they heard both matters because they were related, and they were going to be, to the extent that if this one had moved on, they were going to be on the same discovery schedule.
Okay, thank you.
Correct. Yeah. Thank you.
Thank you, Mr. Lubin. The remainder of your time will be reserved for rebuttal.
Thank you very much.
We'll now hear from Ms. Barnett.
May it please the court. There are two sets of claims at issue here. Mr. Trugstad's religion-based claims under the Free Exercise Clause in the Illinois Religious Freedom Restoration Act, and the substantive due process claim of the plaintiffs named in the second amended complaint. The district court properly dismissed both sets of claims. Mr. Trugstad failed to plausibly allege a religion-based claim, and the district court's denial of leave to amend his religion-based claim was a reasonable exercise of discretion. Plaintiff's substantive due process claim was correctly dismissed because plaintiffs failed to identify a fundamental right, and the COVID-19 policy easily passes rational basis review.
Is that policy still in effect?
It was rescinded in February 2025.
Thank you.
So as we're arguing today, or we're having this proceeding in the courtroom, the city of Chicago has no vaccine mandate in place of any kind. I'm talking about with respect to COVID.
What I can say is that the policy has been rescinded. There wasn't enough kind of factual development in the record for me to speak on the nuances of how that policy is enforced.
Well, it's not a record question. It's just a matter of, is there anything in play with respect to testing, wearing masks, getting vaccinated?
As far as I know, right now, I think the answer is no, but if you'd like supplemental information on that, if the court so orders, I'd be happy to provide a supplemental letter about that.
Or at least for the departments where your client worked, not necessarily the health, like Cook County,
Sure.
maybe that's different, but at least for the fire, water, transportation departments wherever your client worked.
If I don't want to speak out of turn, so if this court would like a supplemental letter on that, I'd be happy.
I mean,
to
the reason, of course, we're asking that question is not to pop quiz you in the courtroom, but rather it can go to subject matter jurisdiction on the relief, on injunctive relief.
Well, our position is that the claims for injunctive relief are moot and declaratory relief because the policy was rescinded. However, Mr. Trugstad does have a claim.
Did you tell us, is that in your brief?
So we asserted in our brief that the plaintiffs who received exemptions, the claims of those plaintiffs as to the substantive due process claim are moot. Again, because there wasn't the kind of factual development in the record to kind of tease out the nuances of that, we didn't make a broader argument. But as to the request for injunctive relief for the plaintiffs who received exemptions, and our position is also any plaintiff who's seeking injunctive or declaratory relief, that would be moot. So turning to Mr. Trugstad's religion-based claims, Mr. Trugstad had to allege some facts about his religious beliefs and how those beliefs conflict with the vaccine, and his allegations failed to satisfy established pleading standards. He only alleged that he's a Christian, he opposed the vaccine on the basis of his religion, and the gene-altering aspect of mRNA vaccinations violates his beliefs as a Christian. These were threadbare allegations. It's not plausible that being a Christian standing alone conflicts with getting a vaccine. Common sense tells us that there are many, many people with Christian beliefs who have been vaccinated, and there's nothing inherent about an alleged gene-altering aspect of mRNA vaccinations that conflicts with Christian beliefs. Mr. Trugstad needed to allege some facts to hold his claim together, and he failed to do that.
Does the case turn on how strong the inference is of connection that Judge St. Eve was talking about, that extra sentence?
It does, that he needed to fill out that claim, and every case, the many that we cite in our brief that has considered this kind of claim, there was more meat on the bones. There was something explaining, some facts explaining what it is about his beliefs, the plaintiff's beliefs as a Christian or whatever they follow, and what about the vaccine conflicts with those beliefs. It's not a high standard, it's just the standard pleading standard, but Mr. Trugstad still failed to meet it. And Passarella does not permit the kind of bare explanation that Mr. Trugstad provided. That decision clarified that a religious objection under Title VII can sound in religious and non-religious terms, but it did not change the requirement that the religious component of the objection must be adequately pled with some factual support. And that's what Mr. Trugstad's third amended complaint failed to do.
What do you do with the allegation, if anything, in paragraph 30, where, at least as alleged, which we have to accept, that the city comes back and wants additional information about his religion, including when he started practicing and all that. So if that's to be accepted as true, what the first part of what you're arguing, at least to some degree, is that you can't read paragraph 28 and construe it as a religious objection. Okay, but the city, his employer, at least for a while, must have interpreted his objection as religious, or else paragraph 30 doesn't make any sense.
I think Mr. Trugstad still needed to put in his complaint what his religious objection is. Those facts needed to be in the complaint. I think that.
So is that to say it's legally irrelevant that his employer thought, believed, concluded that he was objecting on the basis of religion, and it just wanted some more information about the religion?
In this case, yes. In this case, we don't believe you can make that inference from paragraph 30 that what he pled was something religious. It's not, that's not an inference. The fact that it requested additional information does not, Mr. Troopstead still in that response doesn't put in his complaint how he responded. What are the other beliefs that he has? And
Let's fine tune that though. You can conclude from, further to Judge Scudder's question, you can conclude that the matter was religious. It's just the additional facts that are necessary to connect the religion to the vaccine. There's a difference between what you've argued and then what the case law is required.
right, he needs to allege what is his religious belief. He needs to allege in the complaint, put the facts in the complaint that he had a belief that was religious and that it conflicted with the vaccine. Those facts are not in the complaint. It's not on the city to elicit the facts for him or to elicit the questions so that he can fill out his complaint. And he had all the information available to him. His exemption request was denied over 2 years before he filed the third amended complaint. It was denied even several months before he filed his second amended complaint. He had all that information available to him, and he failed to put it in his complaint. And we know that he had it because Mr. Troopstead put it in his motion to reconsider. The full text is right there. There was nothing stopping him from filling out the complaint as he was required to do. And on that score, I'll turn to the denial of leave to amend. A repeated failure to cure deficiencies in pleadings is grounds to deny leave to amend standing alone. And Mr. Troopstead was informed multiple times during this litigation that he needed to allege some specific facts to state an as-applied religion-based claim. He was informed of this when this court denied his request for a preliminary injunction. The city alerted him to this deficiency when he sought leave to file a second amended complaint. And then the district court, when it dismissed Mr. Troopstead's second amended complaint, told him that he failed to include any facts to support an as-applied religion-based claim. And even given all those opportunities, he did not include the facts that he had in his possession. So under those circumstances, the district court was well within its discretion to deny leave to amend based on his repeated failure to cure deficiencies in previously allowed amendments. He was also allowed to amend his Title VII complaint, so he can still pursue his allegations in another case. I'll just briefly address plaintiff's substantive due process claim. This court in Lukashik already rejected this claim. Nothing's changed since then. It's the same claim as was pled there. And every court to have considered the issue, including this one, has found that there's no fundamental right to refuse vaccination and that rational basis review applies. Vaccination's a community matter, and the cases identifying a fundamental right for an individual to refuse unwanted medical treatment don't apply here. And the vaccination requirement here easily passes rational basis review for the reasons that we discussed in our brief. If there's no other questions, we ask that the judgment of the district court be affirmed.
Thank you, Ms. Barnea. Mr. Lubin will give you 2 minutes for rebuttal.
Just a couple things. First of all, the language of Passarella is an employee seeks accommodation because of their religion when their request, by its terms, is plausibly based, at least in part, on some aspect of their religious belief or practice. Based upon that language, a person saying, because I'm Jewish, X, that's a request for an accommodation based on religion. And I think counsel was simply incorrect when she said it's not on the city to ask the follow-up question. At least under Title VII, it's specifically on the city to ask the follow-up question. That if the city thinks that this is not a request for persons based upon a person's religion, it's up to them to say, wait a minute, explain to us how that has to do with your religion. And I think what counsel said was, it's not plausible that being a Christian conflicted with the mandate based upon the fact that other Christians have gotten the vaccine. And respectfully, it's exactly that claim that was really problematic about the city's approach right from the beginning. It's true, there are many Christians that got the vaccine, good people, and there are many Christians that objected to the vaccine based upon their understanding of Christianity. And it's not up to the court, and it's certainly not up to the city to say, this is what Christianity means.
But aren't you proving the point? Because if there are some Christians that do and some Christians that don't, it's what about being the Christian from their perspective makes it a violation.
Sure, and it's the stuff, respectfully, it's the stuff of discovery. What exactly is it about being a Christian that makes, or it's part of the deliberative process that the city was required to engage in, instead of saying, I accept that that's a religious accommodation. There, you don't get this claim later when you come to court that really what you meant was something else, because what I wrote was exactly what he claimed in his request for an accommodation. I accept that that's a religious accommodation. Now tell me about whether you were sincere about it. That's one thing. In terms of, if I could just get 30 seconds.
Sure.
In terms of, my apologies. In terms of mootness, the council did address it in the brief, and it was not just simply, pro forma. There was an argument about mootness that I did want to respond to since it came up. The objection to mootness was the challenge to action. There's an exception to the mootness doctrine, which is when something could be repeated. That exception only applies when the challenge to action is too short in duration to be fully litigated. Clearly, that's the case here. And when there's a reasonable expectation that the same complaining party will be subject to the same action again, it was that second point that they pointed out. I didn't really argue anything, but realistically, these were all employees of the city, and they're continuing to be employees of the city. So if there is another situation like this, it'll be exactly these same people that will be impacted by it, other than Mr. Trugstad, because he's not an employee of the city, and it's certainly not moot as to him.
And Mr. Lubin, currently, the Title VII case pending before Judge Durkin, Rule 16 order has been issued at the end of October.
I'm sorry, what?
The Title VII case,
Yeah.
currently pending before Judge Durkin, a Rule 16 order was entered at the end of October, and that case continues forward.
Yes, that case continues forward. We have we extended our discovery schedule a little bit, but yeah, that case is still moving. Absolutely.
Thank you, Mr. Lubin. Thank you, Ms. Barnea. The case was taken under advisement.
Thank you, Your Honor.